Hey viewers, welcome to this video series by Dr. Peter Onyango, University of Nairobi, Kenya, Kisumu Campus, School of Law. Today I would like to make it clear to you viewers the distinction between the use of tribunal and the court of law. We cannot do this without making some important and fundamental references into the history of tribunal. The word tribunal originally comes from the Roman legal system, in which in the ancient Roman Empire we find the development of three categories of courts or tribunals. The first started by popular court, in which the public, the general public, would present their matters before a judge and get the response or get the ruling there and there. This one carried with itself a lot of corruption, in which parties that were richer than others would be more favored by the justice system. Since the empire was expanding and it could not hold anymore most of the systematic judicial process, we find that another court developed, and this is jury court. The jury court would have a group of judges or a group of persons with various expertise, hearing and determining a particular case to avoid what happened in the past that entailed a lot of corruption. The third development, always in the Roman Empire, came with emperor's court. So emperor's court with appointed judge by the emperor. The judge would portray the powers of the emperor while hearing and determining the outcome of any case brought before the court. However, apart from many other issues, it is the question of the language. Whether you call it tribuna, whether you call it tribunal or tribune, or you call it a court. So there is no much distinction. Let us now come closer to the understanding of the judicial system in our English common law practice, or what we'd call the royal courts in the United Kingdom, where most of the former British colonies derived their judicial traditions. In this case, we find that it was the powers of the king to make laws, to interpret such laws, and also to decree such laws as law binding upon the subjects of the kingdom. And again, the duty of interpretation, it was the judge. That means the king was as well the judge. That is why we talk of the king's bench court. So the king's bench court, that means that it is the king sitting on his throne, that is the crown, to hear and determine the outcome of cases. But as the population of the kingdom became bigger and cases also became more complicated, matters were overwhelming, the king could no longer have that physical and possible capacity to handle all matters brought before it. Now, the king appointed Lord Chancellor, whose role was again to act as the judge on behalf of the crown. With the powers of the Lord Chancellor, which again was overwhelming, the Lord Chancellor had to get judges to work with him But these judges had to move from one shire to another shire to hear and handle cases. And they managed to come up with circuit judges. And in that case, circuit judges would really work according to their mandate without getting involved in corruption matters. This is as compared to, let us say, stable judges in one particular court, which can again promote and encourage corruption. Circuit judges were not in touch with the public and with their parties for a long time, and that one again managed to deal with the question of judicial corruption. But all the same, this is a monarchy and not a republic. In the Anglo-American system, we find that the development of the court system in the American jurisdiction is again taking another format in which the Supreme Court or and the federal courts have got judges that are appointed, and they have the powers from the Constitution of the Republic of the United States to exercise the judicial practice without getting so much involved with other matters. And in that case, in the American system, which is a republic, we find another understanding of the development of the court. But all the same, we have again to go back to the meaning of the tribunal. The meaning of the tribunal in this case, we find that a person or an institution with the authority to hear claims and complaints from the public, those are the parties, and determine its outcome. But another definition is that the tribunal in the common law, Anglo-American common law system, is appertaining to the administration, that is the executive organ of the government. The court belongs by right to the judiciary. Now, there are two powers, of course, and that is the judiciary and the executive, whereby the executive has got the tribunals that operate in the same format with the same process and structures and procedures of the court. The parties will present their case before the tribunal, whether in written submission or oral submission, and the presiding officer in this case could be a judge appointed, or adjudicator, or a public officer with expertise in the law, or has got the knowledge of the law and also the knowledge of that specific specialized area. For instance, if it is a matter of employment, then the employee versus the employer. And in this case, we are dealing with labor issues or labor law matters. And the tribunal set up by that department will again act in the same way the court acts. That means receiving the complaints, determining the admissibility, defining the parties presenting the evidence and their claims, and the hearing set up. At the end, the case will be brought to its logical conclusion with the ruling or the verdict of the tribunal. In any case of dissatisfaction by one of the parties, then the party can appeal, either appeal within the same structure of the tribunals or appeal in the High Court under the division of the judicial review. The division of the judicial review is presided over by an expert judge whose expertise has got so much knowledge on that particular area or matter. If it is matter dealing with the environment, matter dealing with the lands, it will go to the Environment and Lands Court. And if it is a matter dealing with the administrative issues, then it goes through the judicial review. So such petitions are presented to the judicial review, and it is the power of the court to carry out the judicial process according to the law or procedures and bring the matter to its conclusion. Now, again, we find that the tribunal, as used in the common law traditions or in the Commonwealth, common law traditions, Anglo-American traditions, and the tribunal used in the Roman civil law traditions are different. They're different in the sense that if you go, let's say, to France, then you'll find that the tribunal portrays also what the real court of law does. So there is no much distinction. There can be some kind of specialization, but administrative justice is handled by the judiciary just as expected. In Kenya, the administrative matters or complaints are not handled by the judiciary directly, but indirectly through the tribunals. But then the tribunals can refer such matters to the court or the judiciary for maybe further considerations. Now, having this kind of intricate and complicated meaning of the judicial use of the tribunal, we find that every administrative department has got either the board, and such boards also handle certain complaints and hear parties and come up with a ruling. We also get to understand there are certain commissions with the powers of the tribunal. For instance, in Kenya, certain commissions have been set up, commissions for inquiry, that deal with particular issues and provide the reports as required. Kenya has had a long tradition of such commissions that are ad hoc and appointed by the president to hear matters and bring the report to the executive. Yet again, we have the tribunals that are set up by statutes and they belong to such departments as required. We have some that are constitutional. For instance, the Commission on Administrative Justice is a constitutional body. It receives public complaints on administrative services and can again hear such matters in a tribunal format and settle matters at the commission level. But certain matters are referred to the court of law. For instance, the tribunals have got jurisdiction over administrative issues and to some limited cases to civil issues. But most of them that are not belonging to such issues are referred to the court of law. Now, categorically in Kenya, criminal offenses must go to the court of law and not to the tribunal. If in any case, any tribunal is to handle matters involving criminal offenses, then such matters will be deferred to the DPP's office, that is the Director of Public Prosecution's Office, for further considerations and possibly prosecuting such matters formally in the court of law. Now, we can find again that there is a support between the tribunal and the court of law, in the sense that the court of law may not be able or in a position to handle all complaints and matters in the Republic of Kenya. And that is again what brings us to the backlog of cases in court and justice delayed. Now, tribunals complement the courts in the sense that they handle various and several issues and matters before such matters are taken to the court of law. That one reduces the burden or the backlog, and it makes again the access to justice a possibility. We find also that the court of law is very expensive as a process, and lawyers are involved or advocates to stand in for their clients, and that makes it even further costly. Whereas the tribunals, in many cases, the individual party can present himself or herself before the tribunal without taking the risk or the pain of hiring an advocate. But that is not excluded, in the sense that with any possibility, such possibilities can as well be handled, and an advocate can represent a client before the tribunal. In conclusion, it has made us understand the distinction between the court and the tribunal. And in this case, we find that the tribunal and the court under the common law system has got distinction in the administrative matters, whereas in the Roman civil law systems such as France, Italy, Spain, and other countries all over the world that belong to that legal system, they use the word tribunal just in tandem or as a synonymous with the court. So it is like a rank of courts or the hierarchy of courts, whereby, let us say, Corte Suprema or Corte di Cassazione will now be handling the matters just as the Supreme Court. But all other courts below that will be Court d'Appeal, that is Court of Appeal. Then you have the level of the High Court known as the tribunals. They may call them administrative tribunal, or maybe tribunal dealing only with the civil matters. That one doesn't matter. It is the question of the jurisdiction and the legal system in operation in that jurisdiction. So it is just a question of knowing where you are. Are you in China? Are you in India? Are you maybe in Rwanda? Or are you maybe in the Republic of Togo? Or you are in the Republic of Nigeria? So when you want to know which court to go to, or whether to refer your matters to a tribunal, you must first of all ask yourself, which is this jurisdiction? What is the legal system operating within the jurisdiction where you find yourself into? Whether you are in Kenya, or you are in the Republic of South Africa, or you happen to be in the United States of America, or in the United Kingdom. I thank you so much for watching this video. I hope it has cleared some of your doubts when it comes to the confusion between the tribunal and the court. And in Kenya, remember, administrative tribunals. That is what we mean to talk about. They could be ad hoc, or they could be permanent, or they could be statutory or constitutional. It depends on the nature of that particular tribunal, or it may be board, or it may be a commission, or maybe a committee of inquiry. Thank you so much. I still invite you to keep on promoting us, encouraging us to carry on with this lecture series. Thank you.